Good morning, everyone. This is Silvana Pavlovska and In Focus with Silvana Pavlovska. I had made an announcement a few days ago that as part of the series titled Macedonian Question, that I will be introducing a very important question contained in the book, newly published book by Professor Dr. IGOR JANEV, whose title is The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity towards the termination of an illegal treaty. This is a book by AGM Knjiga, Belgrade 2023. This publication, which contains many, many pages, I'm very, very inspired to share with you. And I invite you to make any comments or pose any questions you may have. We have permission from the author of this publication, the PRESPA Agreement as Cultural Genocide of the Macedonian National Identity. We have permission to broadcast this publication, and I'm grateful to Professor Dr. Igor Janev for doing so and trusting me and my YouTube channel to be able to share this with you. In the preface section of the book, it says, in this book, we examine the legal character and political and legal consequences of the PRESPA Agreement, PA for short, as a product of an irregular admission of Macedonia to the United Nations membership. The origin of the treaty is in the UNSC RES 817, 1993, that imposes additional conditions to Macedonian membership in the process of admission in the United Nations. We have presented a detailed analysis of the legal aspects of the SC RES 817-1993 and the GA RES 47/225-1993, which are related to the admission of Macedonia to the United Nations membership. It has been proved that the additional conditions imposed on Macedonia for its admission to the United Nations constitute a clear violation of Articles 4 in brackets 1, Article 2 in brackets 1, and Article 2 in brackets 7 of the Charter, and define a discriminatory legal status of the state as a member, again, in violation of Article 2 in brackets 1, that is sovereign equality. The PRESPA Agreement, or PA, was the first international treaty in the history of international law that impose and externally regulate on non-reciprocal basis the state's name, that is the ID, and national identity of one sovereign nation state, and therefore blatantly violates the basic norms of international law. The PRESPA Agreement violates jus cogens norm with respect of self-determination of people's own national identity and the legal state's name as an element of the judicial personality of state. Therefore, Illegality of that agreement suggests the course of action for termination of the PA as an extremely harmful and damaging treaty. Our current research showed that this treaty is in violation of the basic human rights, covering national minority rights, particularly of ethnic Macedonians in Greece. One chapter of the book, or subsection, specifically deals with these kind of human rights violations. This book is a part of scientific project that has been financed by the Ministry of Education, Science and Technological Development of the Republic of Serbia. Following this preface, which I've read to you in full, in the book contained the PRESPA agreement as cultural genocide of the Macedonian national identity towards the termination of an illegal treaty from Professor Dr. Igor JANEV. It contains the table of contents, and we can see clearly after the introduction, there are 6 chapters in total, followed by a conclusion and appendix. The appendix itself contains many, many references. I shall not go into those at the moment. Following the table of contents, we have the introduction to this book. And I shall endeavor to again share that with you in full before we continue with chapter 1. In history of international relations, there was never a case of a treaty attempting to regulate previous historical events and to establish norms for the interpretation of the history of another state. Not until the international agreement concluded in Nivici, Macedonia, between Greece and the, in quotation, nameless state, described under the provisional name in United Nations, in quotes, the former Yugoslav Republic of Macedonia, end of quotes, or abbreviated the FYROM. The, in quotes, final agreement of the settlement of the differences as described in the United Nations Security Council Resolutions 817, 1993 year, and 845, 1993 year, the termination of the Interim Accord of 1995, and the establishment of a strategic partnership between the parties, end of quote. Hereinafter PRESPA agreement, in quotation, or shortly, in quotation, PA, is unprecedented international act as the first treaty in the history of international law that imposes and externally regulate on non-reciprocal basis the state's name, that is the ID, and national identity of one sovereign nation state. As an external act, this treaty derogate the basic and pillar constitutional provisions of national identity, and contrary to the principles embedded in the Constitution and in the Charter of the United Nations, violates norms of sovereignty and non-interference into domestic jurisdiction of that country. The origin of the PRESPA agreement is in the UNSC Resolution 817 from 1993 that imposes additional conditions to Macedonian membership in the process of admission in the United Nations membership, bypassing and replacing states' legal identity contained in the candidate's application for membership. We have presented an analysis of the legal aspects of the SC Resolution 817, 1993 and General Assembly or GA Resolution 47/225 from 1993, which are related to the admission of Macedonia to United Nations membership, essentially deprived form states' identity and subjected to provisional reference or denomination. It has been demonstrated that the additional conditions imposed on Macedonia for its admission to the United Nations constitute a clear violation of Articles 4, Paragraph 1, Article 2, Paragraph 1, Article 2, Paragraph 7 of the Charter, and define a discriminatory legal status of the state as a UN member in violation of Article 2, Paragraph 1, that is sovereign equality of members' states. The responsibility of the United Nations Organization for violation of Charter's provisions derives from the duty of the organization to respect the basic rights of the states, either as applicants to the United Nations membership or as United Nations members, which are protected by the principles of international law enshrined in the Articles of the United Nations Charter, particularly Article 2. The character of these violations is of ultra vires type with respect to the legal norms of the Charter as a multilateral treaty that obliges organizations to. New state was admitted in United Nations as the nameless international subject, delicta omissiones. The violations of Article 4, Paragraph 1, with respect to procedure for admission in the United Nations, 2, Paragraph 1, related to equality of states, and 2, Paragraph 7, involve the legal personalities of both the organization and the Macedonian state as an independent international person, apparently derived from the right to have a name in the United Nations. Furthermore, we demonstrated here that PRESPA agreement actually violates the basic jus cogens norm with respect to self-determination of people's own identity, enshrined in Article 1 of the United Nations Charter, and the legal state's name, in particular, a choice of the state's ID as an inherent element of the juridical personality, a sovereign identity that is supposed to be inalienable. As an outcome of the partially illegal UNSC Resolution 817 containing additional illegal conditions in form of the PRESPA agreement, hereafter PA, as apparently ill-founded treaty. Namely, PA legally, in effect, systematically eliminates the national identity of Macedonians as a basic collective human right of a nation or national ethnic group and its culture. In addition, we came to conclusion that the PA did not have an expected peaceful and stabilizing impact in international relation and domestically, but rather divided Macedonians into confronted hostile groups, one of those who accepts new ID and the other who rejects the new imposed ID. The ethnic Macedonians, as disputed nation by PA, providing that term Macedonia belonged to Greece only, a presently furiously divided nation confronted between minority who embraced the changed or rather imposed new national identity and majority that rejected new permanent denomination being nationless. Not surprisingly, the ID Subjects Treaty actually established or produced a wide range of internal restrictions and bans on an identity so that it is basically impossible to perform such act legally in domestic arena. What we learned during our research was that this treaty, by its obvious limitations, related to self-determination of people's own identity, including cultural identity, beliefs or traditions, contain provisions that even elevate to the crimes of ethnocide and cultural genocide, including systemic eradication or revision of collective memory. Damnatio memoria. Furthermore, our political analysis showed the PRESPA agreement have produced dangerous and harmful security effects related to territorial integrity, that is, that PRESPA agreement posed serious threats to the very survival of Macedonia as a state by policy of eradication of the nationhood and statehood. In addition, we have showed in our analysis that the change of the national identity violated international human rights, particularly national minority rights of Macedonians in Greece. That kind of violation of basic collective rights could be brought before European Court of Human Rights. That was the introduction contained in the book, The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty by Professor Dr. Igor JANEV, published in 2023, recently. And you are listening to In Focus with Silvana Pavlovska on our YouTube channel. We shall continue today with Chapter 1, Illegality of a state denomination as a consequence of conditions imposed on a state candidate to the United Nations membership, rights of the candidate for the admission to the United Nations, and a legal character of additional conditions for admission to the UN. The, in quotation, name issue, the name issue over the new state of Macedonia emerged in 1991, when the Socialist Republic of Macedonia seceded from the Socialist Federal Republic of Yugoslavia and proclaimed its independence under the name Republic of Macedonia. It should be noted, however, that during the period of Yugoslav or Yugoslavian Federation from 1945 to 1991, Greek state, officially Hellenic Republic, never officially objected or sent any diplomatic note of protest to the Yugoslav state government related to the name Macedonia, in quotation, or any of its variations, Socialist Republic of Macedonia, as a name used for this constituent republic in the former Yugoslav Federation. So-called name issue, in quotation, arose after Macedonia proclaimed its independence and naively, under external pressure and lack of diplomatic experience, started pointless negotiations over its name with Greece in 1992 under the auspices of European Community. As we will demonstrate in this book, objections of Greece were legally groundless. 3 administrative regions that were established in Greece in 1987 even had different names than Republic of Macedonia, official name of the country. Greek administrative regions that were established in Greece in 1987 even had different names than Republic of Macedonia, official name of the country. Greek administrative regions or provinces named in 1987 were 1. Eastern Macedonia with Thrace, 2. Central Macedonia, and 3. Western Macedonia. Neither of these administrative regions were subjects of international law. In addition, when Republic of Macedonia indicated that it will become a member of the United Nations, bear with me for a moment, please, whilst I almost crashed the computer. Let me repeat that again. So, in addition, when Republic of Macedonia indicated that it will become a member of the United Nations, Greek authorities rapidly changed the name of the airport in Thessaloniki from Mikra to Macedonia. And many other name changes of similar nature also took place in order to prove that Macedonia is Greece. under Greek authorities' government. It should be noted that before reforms in the Greek regional administration, Greek department for above-mentioned regions was a ministry of northern Greece. A region was called Northern Greece, not Macedonia. Therefore, at very early stage of genesis of the alleged issue, Hellenic state in the mid-80s tried to monopolize the name Macedonia for historic and commercial motives. And from 1986 through the period of 1993, it renamed many internal subjects in order to achieve exclusively over the name and an ancient period of history. In order to create an artificial brand name, Greek government planned a ban on the usage or the term Macedonia to anyone else. That Greek strategy apparently wouldn't work in case of strong nations as the United States of America, where, for instance, Athens, the capital of Greece, is a city in Ohio and also county in the state of Georgia, that is in the United States, not the one in the former Soviet Union. Connection between the name and the historical content is also vague and apparently manipulative or misleading concept. For instance, in the United States of America exist a dozen of cities called Columbus, and neither of these cities is historically connected with famous explorer and navigator Christopher Columbus, who among others discovered America. In the European Union, legal opinion for former Yugoslav republics delivered in 1992 after the dissolution of Yugoslavia, the famous Badinter's Commission, it was concluded that Macedonia is a sovereign state capable to join the international community. That is opinion number 6 in that document. That opinion was delivered with respect to the Republic of Macedonia, despite the strong objection of Greece claiming that this new country steals their historical name and had issues to resolve with Greece. We shall discuss the opinion later in this book, but at this point, we need to emphasize that it didn't impact behavior of Macedonian president who started the negotiation with Greece over name of the state under EC, even after the opinion was delivered and indicated that any negotiations were superfluous. The admission of Macedonia to membership in the United Nations in April 1993 required the new member to be, in quotation, provisionally referred to for all purposes within the United Nations as the, in quotation, the former Yugoslav Republic of Macedonia, pending settlement of the difference that has arisen over the name of the state, end of quote. The term difference is in quotations. The term difference here refers, I beg your pardon, to the dispute between Greece and Macedonia over the use of the applicant state's name. In its resolution 817 of April the 7th, 1993, by which the applicant state was recommended for admission to the United Nations, the Security Council urged the parties to continue to cooperate with the co-chairman of the steering committee of the International Conference on the former Yugoslavia in order to arrive at a speedily settlement of their difference, end of quote. Thus, the admission of Macedonia to the United Nations was subject to its acceptance of being provisionally referred to as the former Yugoslav Republic of Macedonia or FYROM, and of negotiating with Greece over its name. We have examined at the beginning of our research that the nature and legal basis of these requirements with respect to the conditions laid down in Article 4 of the United Nations Charter for the admission of states to the organization that are limited by its normative nature. The conditions for the admission of states were the subject of exhaustive political and legal deliberations at the United Nations during the 1940s, when many states were applying for membership. During the first several years of the organization's existence, admission to and even representation in the United Nations were subject to various conditions outside the scope of those contained in Article 4 of the Charter, which in some cases required recognition of the applicant as an international subject prior to its admission to membership. In an effort to resolve the dilemmas regarding the legal aspects of the conditions required for admission to membership and to eliminate the various statements that were occurring in the admission process, I beg your pardon, the various stalemates that were occurring in the admission process, the UN General Assembly, by Resolution 113, in brackets 2 in Roman numerals of November the 17th, 1947, requested that the International Court of Justice give an advisory opinion on the following question. By the way, you're listening to In Focus with Silvana Pavlovska. And we are sharing with you a major significant publication titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty by Professor Dr. IGOR JANEV, published 2023, last year, that is. So, let me repeat the last sentence. In an effort to resolve the dilemmas regarding the legal aspects of the conditions required for admission to membership and to eliminate the various stalemates that were occurring in the admission process, the UN General Assembly, by Resolution 113 in Roman numerals number 2 of November the 17th, 1947, requested that the International Court of Justice give an advisory opinion on the following question. Quotation: is a member of the United Nations which is called upon in virtue of Article 4 of the Charter to pronounce itself by its vote, either in the Security Council or in the General Assembly, on the admission of a state to membership in United Nations, judicially entitled to make its consent to the admission dependent on conditions not expressly provided by paragraph 1 of the said article. End of quotes. The following conditions are expressly set forth in Article 4, paragraph 1 of the UN Charter, which provides, quotation, membership in the United Nations is open to all other, i.e., other than the original UN members, peace-loving states which accept the obligations contained in the present charter and in the judgment of organization are able and willing to carry out these obligations. End of quote. The next paragraph of the article states the procedural rule that the admission of any state, this is in quotation, the admission of any state, such state, to membership in the UN will be effected by a decision of the General Assembly upon the recommendation of the Security Council. End of quote. In its advisory opinion, admission of a state to the United Nations, the court first concluded that the question put to it in an abstract form had a legal nature. Consequently, the court was required to provide an interpretation of Article 4, paragraph 1 of the Charter, and by virtue of Article 96 of the Charter and Article 65 of its statute, and as, in quotation, the principal judicial organ of the United Nations, end of quote, it had the competence to give such an interpretation. The court then observed that paragraph 1 of Article 4 in effect contains 5 conditions to be admitted to membership in the United Nations. An applicant must, 1, be a state, 2, be peace-loving, 3, accept the obligations of the United Nations Charter. 4, be able to carry out these obligations. And 5, be willing to do so. Further, the court found that the question put to it by the General Assembly could be reduced to the following, quotation, are the conditions stated in paragraph 1 of Article 4 exhaustive in character, in the sense that an affirmative reply would lead to the conclusion that a member is not legally entitled to make admission dependent on conditions not expressly provided for in that article, while a negative reply would, on the contrary, authorize a member to make admission dependent also on other conditions. End of quote. After thorough consideration, the International Court of Justice, hereafter ICJ, formulated its advisory opinion stating that a member of the United Nations that is called upon by virtue of Article 4 of the Charter to pronounce itself by its vote either in the Security Council or in the General Assembly on the admission of a state to membership in the organization is not judicially entitled to make its consent dependent on conditions not expressly provided in paragraph 1 of that article. Among the most important arguments used by the court in arriving at the above opinion were that, 1, the United Nations Charter is a multilateral treaty whose provisions impose obligations on its members. 2, the text of paragraph 1 of Article 4, quotation, by the enumeration which it contains and the choice of its terms clearly demonstrates the intention of its authors to establish a legal rule which, while it fixes the conditions of admission, determines also the reasons for which admission may be refused. And 3, the enumeration of the conditions in paragraph 1 of Article 4 is exhaustive and, in quotation, not merely stated by way of guidance or example, which follows from the fact that if the opposite were the case, it would lead to conferring upon members an indefinite and practically unlimited power of discretion in the imposition of new conditions. End of quote. In its deliberations, the court specifically analyzed whether the political character of the organs responsible for admission, that is the Security Council and the General Assembly by virtue of paragraph 2 of Article 4, or for the maintenance of world peace, the Security Council pursuant to Article 24 of the Charter, engendered arguments leading to the contrary conclusion regarding the exhaustive character of the conditions enumerated in paragraph 1 of Article 4. The court rejected this interpretation and held that the political, this is in quotation, the political character of an organ cannot release it from the observance of the treaty provisions established by the Charter when they constitute limitations on its powers or criteria for its judgment. End of quotes. Thus, the Charter limits the freedom of political organs, and no political considerations can be superimposed on or added to the conditions set forth in Article 4 that could prevent admission to membership. This does not mean, however, that the conditions of Article 4 preclude taking into account relevant political factors that fall within this scope. Appreciation of such factors derives from the very broad and elastic nature of the prescribed conditions, and according to the court, it does not contradict the exhaustive character of these conditions. However, political organs interpreted the absence of diplomatic recognition from Greece with respect to name as an element of statehood as a sort of a dispute between the countries, and apparently unaware of the advisory jurisdiction of 1948, wrongfully placed illegally illegal additional conditions in the process of Macedonian admission to the United Nations Organization. The advisory opinion of the court makes it apparent that besides their exhaustive and explicit character, the conditions laid down in Article 4 of the Charter have two additional characteristics. One, they must be fulfilled before admission is effected. And two, once they are recognized as having been fulfilled, the applicant state acquires an unconditional right to United Nations membership. This last feature also follows from the, in quotation, openness, close of quotation, to membership enshrined in Article 4, which comports with the universal character of the organization. The advisory opinion of the International Court of Justice was presented to the General Assembly at its third session in December 1948. At that session, the General Assembly adopted Resolution 197, paragraph 3, by which it recommended that each member of the Security Council and the General Assembly, in exercising its vote on the admission of new members, should act in accordance with the foregoing opinion of the International Court of Justice. End of quote. This resolution and the court's advisory opinion have direct legal relevance to the issue of the admission of Macedonia to membership in the United Nations, since these documents interpret the Charter in a manner that limits the power of the United Nations organs to impose conditions on admission. The preamble to Security Council Resolution 817, by which Macedonia was recommended for admission, recognized that, in quotation, the applicant fulfills the criteria for membership laid down in Article 4 of the Charter of the United Nations, end of quote. According to admission of a state to the United Nations and General Assembly Resolution 197/3 from 1948, this statement means that the applicant has fulfilled all the required conditions for admission to membership in the United Nations, and that no other conditions may be imposed. Contrary to the usual wording of Security Council resolutions recommending admission of a state, Resolution 817, after recognizing the fulfillment of the conditions in Article 4, contains an additional consideration, quotation, that a difference has arisen over the name of the state, which needs to be resolved in the interest of the maintenance of peaceful and good neighborly relations in the region. End of quote. This condition, which is found in the introductory part of the resolution, is reflected in its paragraph 2, which recommends the admission of the applicant state to membership in the United Nations. It describes, in quotation, this state as, in quotation, being provisionally referred to for all purposes within the United Nations as, in quotation, the former Yugoslav Republic of Macedonia, pending settlement of the difference that has arisen over the name of the state, end of quote. Instead of interpreting lack of political or diplomatic recognition by one state as a matter that couldn't transform into the international dispute, the Security Council labeled candidate for a membership with a mandatory, in quotation, reference only for United Nations purposes, and created a real problem for a new member to get rid of the ban on its name and to replace humiliating provisional name that actually symbolized universal non-recognition of its constitutional name. It should be noted that Security Council, by its recommendation addressed to UNGA, didn't create the security issue, but rather minor, undefined, in quotation, difference that have to be resolved. The Macedonian government strongly objected to the use of this provisional name or reference, stating that, in quotation, under no circumstances, end of quotation, was it prepared to accept that designation as the name of the country. Nevertheless, the text of the resolution remained unchanged, and the official name was replaced with a provisional quotation name. As a consequence, the imposed obligation to accept this provisional denomination and the closely related obligation to negotiate over the name of the country served as additional conditions that it was required to satisfy so as to gain admission to the United Nations. In that moment, Security Council hadn't realized that recommendation to the United Nations General Assembly was to admit the nameless member state, as this entity was supposed to be a sovereign state with the ID. That is, United Nations Organization is an association only of sovereign judicial persons in their full membership. In addition, the United Nations General Assembly also couldn't grasp that deficiency and illegality of Resolution 817, proposing nameless subject to the United Nations membership, delicta omissiones. These unusual conditions in Resolution 817 are extraneous, I beg your pardon, to the limited list laid down in Article 4. Furthermore, these conditions transcend the act of admission in time. Since the Charter makes no provision for other conditions for admission, it appears that the conditions imposed on Macedonia have no legal basis. Certainly, the ICJ's advisory opinion makes clear that all the conditions for admission to membership must be fulfilled before admission is effected. Since the conditions that were imposed represent purely political considerations, they are incompatible with the letter and spirit of the United Nations Charter. Also relevant is the fact that Security Council Resolution 817, after explicitly recognizing that the applicant state had fulfilled the criteria for membership laid down in Article 4, recommended to the General Assembly that the state be admitted. The act of recommendation necessarily recognized that the conditions of Article 4 had been fulfilled. The additional conditions that were attached to the recommendation of Macedonia for membership in the United Nations therefore created a logical inconsistency because the Charter contains a closed list of requirements. Once those requirements are found to have been satisfied, the state has a right to admission. Additional conditions attached by the Security Council and General Assembly appear to negate the conclusion that the state is entitled to admission in accordance with the Charter conditions that were met. Thus, the recognition of its fulfillment of the conditions for admission means that the Security Council affirmed that the applicant country is a peace-loving state, all able and willing to carry out the obligations in the Charter, which include, among others, the obligations set forth in Article 2, paragraph 4, quotation, all members shall refrain in their international relations from the threat or use of force against the territorial integrity or political independence of any state or in any other manner inconsistent with the processes of the United Nations. End of quote. On this basis, it appears contradictory and incompatible with the law for the Security Council resolution to report that a difference has arisen over the name of the state, which needs to be resolved in the interest of the maintenance of peaceful and good neighborly relations in the region. End of quote. This provision implies that the applicant state is unwilling to carry out the obligation contained in Article 2, paragraph 4. The ICJ's above-mentioned advisory opinion and General Assembly Resolution 197/3/1948 do not permit such contradictory statements. Either the test for admission is met or it is not. The principles of exhaustiveness, explicitness, prior fulfillment, and recognition, which are embedded in the court's interpretation of the conditions of Article 4 of the Charter, must mean that it would be logically inconsistent for additional conditions to be attached to the resolutions that recommend or the decisions that provide for the admission of a state. It can be argued that the logic of the court's opinion also relates to the provision of Article 2, paragraph 7 of the Charter, which states, quotation, "Nothing contained in the present Charter shall authorize the United Nations to intervene in matters which are essentially within the domestic jurisdiction of any state, or shall require the members to submit such matters to settlement under the present Charter." End of quote. Thus, in interpreting this paragraph in connection with the admission of states to membership in the United Nations, Judge Krylov, who took part in the 1948 ICJ proceedings, stated that, A, quotation, "Member of the United Nations is not justified in basing its opposition to the admission of a particular state on arguments which relate to matters falling essentially within the domestic jurisdiction of the applicant state." End of quote. This statement reiterates the principle embedded in the advisory opinion of the court and in General Assembly Resolution 197/3/1948 that once the appropriate UN organs determine that the criteria of Article 4 have been fulfilled or met, neither a UN organ nor a member of the organization can condition the admission of the applicant state on any additional consideration, particularly if it essentially falls within that state's domestic jurisdiction. Certainly, the name a state wishes to adopt is a domestic constitutional matter, having no direct impact on any other state. Furthermore, on the basis of the principle of separability of domestic and international jurisdiction, it can be argued that the substantive Greek allegation that the name of the applicant implies territorial claims is in a quotation, has no legal significance. I'll repeat this again. Furthermore, on the basis of the principle of separability of domestic and international jurisdiction, it can be argued that the substantive Greek allegation that the name of the applicant implies territorial claims has no legal significance. Obviously, the name of a state, which is a subject of that state's domestic jurisdiction, since every state naturally has an inherent right to a name, does not create international legal rights for the state that adopts the name, nor does it impose legal obligation on other states. Clearly, the name per se does not have a direct impact on the territorial rights of states. My apology. We shall continue with that. Clearly, the name per se does not have a direct impact on the territorial rights of states. Greece advanced particularly the same objections and demands as regards the recognition of Macedonia by the members of the European Community. Nevertheless, the EC Arbitration Commission on former Yugoslavia did not link the name of the country, that is Republic of Macedonia, to Greek territorial rights. Prominent scholars of international law have expressed similar views. For instance, in their course book on international law, Professors Henkin, Pugh, Schachter and Smith observed that there, in quotation, appears to be no basis in international law practice, end of quote, for the Greek demand that Macedonia change its name. Quotation, claiming that the right to use the name should belong exclusively to Greece, end of quote. It is apparent that the Greek demands regarding the name of Macedonia are motivated mainly by concern that the admission to the United Nations of a state with that name may add strength in the political arena to, quotation, possible Macedonian claims to Greek territory, end of quote. The name itself has no legal bearing on such a potential, quotation, dispute. and no relevance to the qualifications that may legally be considered in conjunction, or I beg your pardon, in connection or conjunction with the admission of a state to the United Nations. To nullify the Greek concerns that the name of the country implies territorial claims against Greece, Macedonia adopted its amendments to its constitution on 6th of January 1992. They assert that Macedonia, in quotes, has no territorial claims against any neighboring states, end of quote, that its borders can be changed only in accordance with the constitution, and, quotation, generally accepted international norms, end of quotes, and that in exercising care for the status and rights of its citizens and minorities in neighboring countries, it, quotation, shall not interfere in the sovereign rights of other states and their internal affairs, end of quote. It can further be noted that after the two countries concluded the interim accord of September the 13th, 1995, under the auspices of the United Nations, their relations entered into a period of steady and progressive development. But Macedonia had to pay a price for that by recognizing and admitting in the provisions of treaty that there was a, quotation, dispute, and that two countries, quotation, negotiate over the name of state provisionally referred to as FYROM, labeled simply as second part in the interim accord of 1995. So, Macedonian government was trapped and played out once again, now recognizing the government negotiate over the name of a country, unaware that negotiations entail preparation for later compromise, by definition erga omnes, that will in fact erase the essential elements of its national identity, fundamental matter that we will discuss in the following chapters of this monography, says Professor Dr. Igor JANEV in his publication of 2023, titled The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty. From the point of view of legal theory, the inherent right of a state to have a name can be derived from the necessity for a judicial personality to have a legal identity. In the absence of such identity, judicial persons, such as a state, could, to a considerable degree or even completely, lose its capacity to conclude agreements and independently enter into and conduct its relations with other judicial persons. Therefore, the name of a state appears to be an essential element of its judicial personality and its statehood. The principles of the sovereign equality of states and the inviolability of their judicial personality lead to the conclusion that the choice of a name is an inalienable right of the state. In this context, external interference with its basic right appears to be inadmissible, irrespective of territorial and similar arguments by any side. This conclusion is consistent with the previously cited opinion of Henkin, Pugh, Schachter, and Schmidt that states have no exclusive rights to names under international law. Perhaps the international community should develop appropriate legal mechanisms and rules for hypothetical situations when two or more states wish to adopt the same name. However, this is not the case in the Greek-Macedonian dispute, since the name Macedonia is used by Greece to designate its provinces, which are not an international legal persons, i.e. belonging to another category. The question of a judicial linkage between the conditions for admission to UN membership and the conditions for recognition of a state was deliberated in the United Nations at the beginning of the 1950s. A memorandum on legal aspects of representation in the United Nations was prepared by the Secretariat and communicated to the Security Council. The memorandum emphasized that the recognition of a state and its admission to UN membership are governed by different rules. Recognition is essentially a political, in quotation, decision of individual states, whereas admission to membership is a collective act of the General Assembly based on the right to membership on any state that meets the prescribed criteria. Therefore, there is no link, judicial or otherwise, between the conditions for recognition of a state by another state and the conditions for admission as a member of the United Nations. On this basis, the memorandum stressed that it is inadmissible to condition admissions on recognition, since admission does not turning the page over, since admission does not imply recognition by any government. This conclusion is consistent with the previously discussed advisory opinion of the International Court of Justice and with the principle of universality of the United Nations. Furthermore, from the same document, we may conclude that the UN organization is not legally entitled to recognize states, diplomatically or politically, or any basic element of their statehood, such as basic states' legal ID. In conclusion, once the conditions set forth in Article 4 of the UN Charter have been fulfilled, the applicant state acquires an inalienable right to UN membership. On the basis of the Security Council's assessment or the report that Macedonia had satisfied the conditions of Article 4 and General Assembly Resolution 197 regarding observance of the advisory opinion of the International Court of Justice, it appears that the Macedonian application for membership should have been handled in accordance with the existing standard admission procedure and law. The additional conditions related to the name of the state constitute a clear violation of the United Nations Charter and basic rights of the state and a nation candidate for UN membership. As the final effect and result of the additional obligations that were identical as imposed illegal additional conditions, emerged the compromise, the PRESPA agreement, as an act that required fundamental revision of domestic national constitution and hence an instrument by permanent external interference in internal affairs and jurisdiction of the nation state, including demands for redefinition of the nation itself. That compromise, the PRESPA agreement, affects not only the rights of the state, subordinating one state by another state, but also collective human rights of one nation as a national group and community that, according to Resolution 817, needed to be redefined contrary to the principles of self-determination and non-discrimination in the United Nations membership. Further examination of imposed restrictions on national terms in domestic legal order will lead to inability to perform or implement an external act or treaty in practice in internal relations where freedom of expression and thought are supposed to be basic pillars of any non-autocratic system of government. In addition, the change of the national identity will most certainly violate international human rights, such as minority rights of Macedonians in Greece and elsewhere in the world. And if I might add in Australia and everywhere where Macedonian people happen to reside. This was the end of chapter 1, contained in this thesis publication by Professor Dr. Igor JANEV, an expert on law, a person of Macedonian background, who's written many, many books. Books, one will say, containing factual information that is the truth. The title of this book, which came out in 2023, is The PRESPA Agreement as Cultural Genocide of the Macedonian National Identity Towards the Termination of an Illegal Treaty. I thank you for your patience, for your attention. Thank you for this opportunity to share this information with you. And I'm really thrilled that this information has been provided to all of us, not just in Australia, elsewhere in the world, including Macedonia and Greece, in the English language, so that more people have an opportunity to be informed and ask questions, just like the Macedonian Socrates did many centuries ago. Ask questions. Do not believe what those who are in a powerful position, do not believe the narrative that they're dishing out. And there's been a lot of narrative over the many decades. Certainly I've been a witness to those narratives during my education here in Australia, through secondary school as well as universities that I have attended, one of which is my Wollongong University, where I obtained my postgraduate degree in journalism. So do ask questions, be informed, and speak out, speak up, speak up. I welcome your comments, I welcome your questions, and we shall continue with chapter 2 in the next few days. So these YouTube videos of In Focus with Silvana Pavlovska are available, are in the public domain, so you're welcome to listen and re-listen and also share with others. Once again, thank you for your attention. I'm grateful to you.